morning. It's very, very well briefed. Let's go ahead and proceed. Mr. Apple.
Yes, Your Honor. We have filed our application for temporary injunction, and as the court will recall, we had a hearing back a month ago for a TRO, and basically the issue before this court focuses around an easement that has existed for a number of years, and the easement involves a access driveway that leads from 7th Street in Irving back to the plaintiff's home. My clients, the abides, are the owners of the property across which this easement exists. And as we stated in the TRO hearing, and again, my clients have installed this gate across this gravel drive in order to keep trespassers, unwanted people, from accessing my client's property. And I believe we have provided the court with some videos. My client's property is in the back also, but to keep people from driving back there, which they've been doing, and putting my client's family, their grandchildren, at risk when they're outside playing. And again, this is a gate that all parties access to get to their respective homes. The easement in question.
So is it true that this easement has been in place for about, what, 67 years? And
yes, Your Honor. It's dated, I think, back in the 50s or 60s. Yes, it's been there. And the properties have been sold over periods of time.
And during that 67 years, there was never a gate in this location, and it's only recently been installed?
Your Honor, I don't know whether there's ever been a gate there or not. My clients have owned the property since December of last year. The plaintiffs have owned their property a little longer than that. But again, this easement is between two prior property owners that date that far back. And so whether there's a gate there before or not is really irrelevant to the analysis, because the analysis—
Isn't that exactly though what the Beaumont court that Mr. Thorne cited to, isn't that one of the kind of critical issues we look at, is whether or not there had been previously been a gate? Isn't that exactly what's cited in that case? I
disagree with that, Your Honor. Are you talking about the Emmons case?
I'm sorry, I don't remember the name of the case. Is the one out of Beaumont?
Yes, that's the Emmons case, Your Honor. The Emmons case we cited back during the TRO hearing. There are two cases that I found researching this whole issue dealing with an access easement involving the installation of a gate. And there were two cases that I found. One was the Barrow case, and one was the Emmons case. The Emmons case is the Beaumont case that Mr. Thorne cited, and that we also cite, because what the courts in both of those cases look at is they look at the language of the easement. And that's the language that dictates what happens in this case. If you have an easement document that is unambiguous, which is what we have in our case, then the court is bound by the four corners of that easement. You don't look out, you don't look at equities, you don't look at past facts, future facts, you look at the document itself. And in the Emmons case, what was different in that case is that easement specifically had language that we don't have in our case. And that's why I think our case is more comparable to the Barrows case, because that case didn't have the language in it either. Emmons had language that said free and it said uninterrupted and free. It had those two buzzwords in it regarding the easement. We don't have that in our case.
So can you share screen Exhibit G that I think is the critical kind of, is that the easement that we're talking about?
Let's see if I can. I'm getting to it, Your Honor.
Mr. Apple, are you still there?
Yes, Your Honor. I'm just trying to get to the document. I apologize. There we go. So that is Exhibit G, which is the easement that we're dealing with in this case, Your Honor.
And this is, it indicates that there's a perpetual right of way for road purposes along a 15-inch strip out of the tract of land. That's kind of the operative language, correct?
Yes, 15 foot. And that is very similar to what you have in the Barrow case.
All right, show me the Farrow decision and kind of what exactly the language was in that case.
So the Barrow case.
You said Barrow or Farrow?
Barrow, it's Barrow. It's in the notebook that we provided. But the language in that case, pulling it up real quick. Because again, it's what's quoted as the court in that case. It says the grant was a 30-foot access easement on, over, and across the easement track. And the court goes on, it says the agreement stipulated that the easement be a, quote, perpetual, non-exclusive easement for pedestrian and vehicular ingress, egress, and access on, over, and across the easement track. That was the language that's cited in that case. And then in the Emmons case, the language goes beyond that and says non-exclusive, free, and uninterrupted use. And that's what the court picked up on Emmons and said, because it says free and uninterrupted, therefore the court in that case said you couldn't install a gate. But because that language is not included in the easement that was granted in Barrow, which is similar to our easement, the court said you could have a gate. Because you can't read words into the easement document unless it's ambiguous, and we don't have an ambiguous document here, as admitted to by the plaintiffs. So the language is what controls in this case as to whether or not my clients are entitled to have a gate across this driveway, which they have to access just like the plaintiffs. They have to get out, stop, open it, close it. And so it's not, and anyone can access it. It's not locked. It's never been locked. It has a sleeve on the middle bar that can be removed if some large vehicle needs to get up and down. So the only issue is whether, for purposes of the easement, is are my clients entitled to have a gate on their property across this drive that serves both the plaintiffs and my client's home. And based on the Barrow case, the answer is yes. And based on the Emmons case, the answer is yes. Because the language free and uninterrupted, that wording is not in this easement. And that's what Emmons relied upon to exclude a gate.
Mr. Thorne, how do you distinguish the Barrow case? And would someone share screen the Barrow case for me?
We
Mr. Thorne, are you there?
yes, Your Honor, we're pulling up the Barrow case. The distinguishing factors are that in Barrow, the court emphasized that the dominant estate, the people in the position of my clients, the plaintiffs in this case, only accessed the property 30 to 40 times a year for purposes of recreation or hunting, as opposed to the plaintiffs in this case living on our property, using it, accessing the road 30 or 40 times a week. And in the Emmons case, the court.
Let's deal with Barrow first. So,
Okay, I'm sorry.
so your argument is that although the language is very similar to the Barrow case, the number of times they had to go in and out was kind of dispositive, and that case is
that's what the court emphasized, as did and in the Emmons case, in fact, it in the first column that we're looking at up in the upper left-hand corner, the court said that picket passes along the easement 30 to 40 times annually, primarily for hunting. Makes a big difference. Counsel's argument is you have to look in the four corners of the document. However, both the courts in this Barrow case and the court in Emmons emphasized factors that are actually the practical usages for the easement property. So they didn't confine themselves to strictly reading the language. They looked at how was the property used and the history of prior gates. In Barrow, there was a history of gates having been placed in this roadway previously. So in Emmons, and so the court ultimately in Barrow said it's okay to put up a gate because there had been gates there before, and because it's only used 30 to 40 times a year. So it's not that big an inconvenience. In the Emmons case, that was the way that the Emmons court distinguished Barrow was on those factors. That in Emmons, there had never been a gate put up before in the 40 years of usage of that easement. And they also referenced the fact that Barrow was distinguishable by the small amount of usage and by the dominant estate owner.
Let me see. Where does it say that?
On Emmons, it's on the last. Well, can we look at page 5 on Emmons? The last 4 or 5 lines from the bottom says, because in Barrow gates had been erected on the easement in the past, and then with respect to usage, it's mentioned in here. Now let's see.
Your Honor, what he's referring to is they're quoting language from another case.
Well, they're distinguishing Barrow. The Emmons court distinguished Barrow by those 2 factors, that there'd been a gate previously put up on that easement in Barrow, and in Barrow, there had been fairly infrequent usage.
So it looks like this court looked at both the language, but also the usage is kind of what you're saying.
That's exactly what the court did, Your Honor.
And I disagree with that.
I'm sorry. And the testimony in our depositions that we developed and have presented to the court was, we don't know prior to 1998 However, Ms. Kiziar testified she acquired her property, which adjoins the easement road, in 1998. There had never been a gate during that entire time, so 23 years. I think we can assume there was never a gate at all. It was, in fact, Exhibit 2. Can we look at that Exhibit 2, which is the handwritten document of Mr. Dickinson?
And Your Honor, if in the Barrow case, I mean, these arguments are the same arguments that are being made in these cases that counsel's making. And in Barrow, I mean, the court even pointed out, he said, in this case, it was Pickett who was as if the plaintiffs, and he said, Pickett's argue that because no gates existed previously, it was the intent of the parties to maintain the status quo, a road without gates. Court says, however, Pickett's argument ignores the emphasis courts place on the unambiguous written agreement. So you can argue whether there was a gate or not. That doesn't matter, Your Honor. The courts in both cases, as well as the Supreme Court in the Marcus Cable case and other cases, are very clear. This court's decision is limited to the four corners of this easement. If it doesn't,
What are the facts of that case, the Supreme Court case you just mentioned?
The Marcus Cable case was a case involving where they were granted an easement dealing with utilities. And in that case, they went beyond the language. They were I believe they were installing more utilities and using the easement for broader purposes than what was granted. And the court, and again, getting back to the analysis, the court said you have to confine your decision to the four corners of that document unless they're ambiguous. And if they're not ambiguous, then that's what you look at. And that's what you base your decision on, or the wording. And that's why I said the Emmons case, what is compelling about Emmons is the fact that it includes what I call the magic words, free and uninterrupted, which we don't have in our case. And that's why Emmons said you can't have a gate. Barrow doesn't have that wording, and Barrow says you can have a gate. I mean, it's really that simple, Your Honor.
Mr. Thorne?
May it please the court, I disagree, obviously. I think the courts in both those cases looked at some outside factors. The outside factors of usage prevailed in favor of the dominant estate owner in the Emmons case. This was as opposed to the minor usage in Barrow. And in our case, we know that the property is the home and was built as an intended homestead whenever it was built many, many years ago at the end of this easement, which is a driveway off of West 7th Street. And when that easement created in 1954 said that there was a perpetual right of way created for road purposes, we don't put up a barrier on somebody's road, much less in their driveway. And if I can briefly go back to this argument of the defendants, that the pretext that they've presented for the reason for putting up the gate as being for safety, the testimony in the depositions by Ms. Kiziar, Ms. Ballard, and Mr. Hawkins. Mr. Hawkins and Kiziar have over 20 years familiarity with the road. They've never had trespassers, vandals, safety issues. There's never been anything like that. On the contrary, the real reason for putting up this gate by Mr. Abad was his plan to develop his property, and he needed that little finger. Can you put up our plan?
I recall what you're talking about. I remember.
Yeah, the little finger. He wanted that finger to access off of 8th Street and be able to build houses on his property. And when the plaintiffs wouldn't give him that finger, that's when, oh, well, the gate appeared. And now it's not for intimidation of them into giving him the property. It's for safety, which is, again, pretextual.
Your Honor, again, I think all that's irrelevant. Two, the plaintiffs have an electric gate that they have to go through to access their drive in their house. Their entire property is fenced. They have an electric gate. So obviously they think safety is an issue. Otherwise you don't have gates and fences around your property. Three, Your Honor, my clients, just like the plaintiffs, and as well as my clients' children and grandchildren, they all have to access the gate. So everyone accesses this gate. They can argue all they want about pretext, but the issue is my clients installed it to protect their family. And they want to be able to protect their family. They got grandkids. I have grandkids. I would hate for my kids to get run over by somebody driving on my property.
I guess your argument is that somehow they go into this back driveway, like,
Yes.
and that somehow the kids will be running on the driveway and then get hit.
Well, if you look at the video, Your Honor, when you go down the drive, there's several acres back there, wooded acres. And you have a gravel drive that goes around my client's home. And back behind their home, there's several acres of land that's undeveloped. And so my client's grandkids, it's their property. They can run all over that area as grandkids. I mean, that's what kids do. That's why they have their home, is they can be able to go and run and be free. And so when they have people driving back around their property during the day or even in the evening that are not supposed to be back there, this is their way of stopping that. And they have the right to do that as a property owner to protect their property. And under the law, this easement gives them the right to do that, to have a gate. There's nothing in this easement that says they can't do that. The only way they would be precluded from doing that is if this easement said free and uninterrupted. If it has that verbiage, and we don't have that verbiage here. We have the verbiage that's similar to Barrow.
Mr. Thorne, do you have any cases that have the language that we have in this case that doesn't say free and uninterrupted, where a gate was taken down or not allowed?
I don't have my hands on any right now, Your Honor. I just think that we have a grant of perpetual right of way for road purposes. We can't, what are they going to be allowed to do? Charge a toll at the road? How many gates can they put up in our road, which is actually our driveway to our home? And the testimony we have is these people don't just leave the home in the morning, come home at night. They're in and out of the home all day long. So it's not just for their convenience, it's for convenience of deliveries, for emergency vehicles.
Isn't there testimony that the Amazon drivers and other delivery vehicles are not impeded by this gate?
Yes, right.
The testimony by Ms. Ballard that was her concern, that Amazon drivers, pizza deliveries, emergency vehicles are all impeded. What are they going to do when they drive up to a gate, which is 50 yards from the home? They're going to turn around and leave or dump the goods out on the ground there. It's just, this gate is not practical. The real solution, if safety were an issue, is to put up a gate or a fence in front of the Abide's house, just like the plaintiffs did at their house, put up a fence.
Your Honor.
Go ahead.
Again, Your Honor, I mean, my clients, their property is on acreage. We're not talking about a small lot. We're talking about a very large piece of property. And this is where the gate that my clients have the same issues as the plaintiffs. And again, from a convenience factor, the evidence is very clear. No one has been prevented from accessing their property. We haven't had issues with emergency vehicles accessing property. We haven't had issues with delivery services accessing the properties. My client's home is back where the plaintiff's home is. I mean, they're both back off the road. So again, council can make all these, what I call equity arguments. The issue is the law and the easement itself. And the easement is what it is. It doesn't have this magic language that council is hoping it has. And again, based on the case authority, it's very clear my clients are entitled to have a gate. And again, it's unlocked.
You know, looking at the case law and the facts of the case, this is not the way I wish it would go, because I think this gate was probably put up for protectional reasons, but given the language of the easement, I think I'm going to have to grant a TI on this. And so we'll grant a TI. I think we have a trial setting already on this, in April, is that correct?
Yes, Your Honor.
Is this whole case just about whether or not this gate's going to be open or closed?
Yes, Your Honor.
Okay.
Here we are. All this over Mr. Ebad putting up his gate. However, I would say this, if somebody put up the gate in my driveway, I'd just bulldoze it, but these parties have chosen to.
I don't blame your client. I think this is kind of a. Yeah,
again,
I don't
Your
know
Honor, I'm not going to.
Anyway,
Over the point.
it is what it is. And so the law is what it is. I've got to follow the law. I don't necessarily agree with this, but that's what the law says I have to do. Go ahead and prepare an order for me, Mr. Apple. Go ahead and make sure it says on October 4th. This was heard on October 4th, 2021. I do want to make it clear that this is the only gate that's going to be allowed. I do share Mr. Thorne's concern that you can't just build a bunch of gates. So that needs to include in there, this is the only gate that's going to be allowed. I don't think there's any case law that says they can build multiple gates. And just get that order to me, share it with Mr. Thorne, and then e-file it and email it, okay?
And Your Honor, we've already submitted, we've e-filed a proposed order. I've also emailed it.
Go ahead and change it the way I said. And
I'll make those changes. Thank you, Your Honor.
all right. Anything else, guys?
No, Your Honor. Oh,
And Mr. Apple, I don't know who did the briefing for you, but I thought it was very good. Whoever briefed it did a very good job.
thank you, Your Honor.
Was that you or a young lawyer?
No, that was me.
Okay, well, good job then. It's usually a young lawyer, but this time it was good.